Friday, the 21st of June. The clerk will now proceed to read the orders of the day.
Investigatory Powers Amendment Bill, Lords, second reading.
Minister to move second reading.
No.
Minister to move second reading.
Mr. Deputy Speaker, I beg to move that the bill now be read a second time. So, the first duty of government is to keep its citizens safe. The United Kingdom faces an enduring threat from terrorists, from hostile actors, and from organised criminal groups, and that threat is evolving and becoming more sophisticated. It is not enough for us to keep pace with those who do us harm. We must endeavour to get and then stay ahead of them. The investigatory powers are the legal powers available to law enforcement, to the intelligence services, MI5, SIS and GCHQ and other public authorities, where appropriate, to obtain communications and data about communications. The Investigatory Powers Act of 2016 provides a clear legal framework for the use of these powers, combining world-leading safeguards and oversight with giving agencies the tools that they need to protect us. There is a double lock for the most sensitive IPA powers, meaning that an independent judicial commissioner must approve a decision by the Secretary of State to issue a warrant under the IPA. The use of any of these powers must be assessed as necessary and proportionate, with a strong independent oversight by the Investigatory Powers Commissioner. And the Investigatory Powers Tribunal provides a robust mechanism for providing redress in respect of any unlawful use of those powers. I will.
I'm grateful to the Home Secretary for giving way, because he will be as aware as I am that very, very occasionally those in charge of our intelligence and security services don't act in the best traditions of this country and with their offices. And I'm thinking of cases like Belhaj and Boudicca. So where people have been the victim of mistreatment as a consequence of UK complicity with foreign powers, for example, should there not be a right for these people to have access to the information about that?
I listen carefully to the point the right honourable gentleman has made. I'm not sure it's directly relevant to this, but I will take on board the points that he made, and he'll forgive me if I don't address them directly just at this point. So I want to consider them properly. The IPA is sound legislation, but the nature of these threats has evolved since 2016, and we are confronted by greater global instability and technological advancements, and they demand that we act. Terrorists, child abusers, organised criminals and malign actors from hostile states have exploited technological advances, and our job is to ensure that the UK's investigatory powers framework remains fit for purpose. The changes that this bill proposes were informed by the independent review of the IPA published by the Noble Lord Anderson of Ipswich in June 2023. The bill received cross-party and cross-bench support as it passed through the other place. Every government amendment was accepted, and I want to thank the members of the Intelligence and Security Committee of Parliament for the productive way that they engaged with and helped to shape the bill. In particular, we have agreed to tighten the drafting of clauses 22 and 23 in line with amendments proposed by the Intelligence and Security Committee. These changes put beyond doubt that the Prime Minister can only delegate warrants for the purposes of obtaining communications of parliamentarians in two and only two exceptional circumstances: the personal incapacity of the Prime Minister, or if there is a lack of access to secure communications. There is also a limit of 5 Secretaries of State to whom this responsibility could be, in those circumstances, delegated. Further to this, In respect of the new Part 7A, parliamentary scrutiny will be enhanced through a statutory requirement for the Secretary of State annually to inform the Intelligence and Security Committee about the new regime for bulk personal data sets. And I will give them.
Sir John Hay.
Great, my friend. He's mentioned the ISC scrutiny of these matters, and he will understand the concern about widening the number of people who can play the role that's previously been played exclusively by the Prime Minister. Has he considered possibly in doing so, and I can understand the reasons for that, by the way, limiting that to those Secretaries of State that have warranting powers?
We had looked at that. I think there is a balance to be struck, and actually the Secretary of State to whom this function could, in those two exceptional circumstances, be delegated, the bulk of whom do have warranting powers. I think the Secretary of State for Defence being the only one that does not. But so I think the point he's made is a fair one, but the scope of the bill is not much greater than the point that he put forward. I'll now turn to the. Of course I will. Of course I will.
As a member of the IC, I welcome the government's accepting our recommendation on this, but I'd like to understand why the government aren't accepting our other proposal, which is a very simple one, is that when a delegation takes place, that the Prime Minister will be informed about that afterwards.
Yeah, I think it is inconceivable that the exercise of a delegated authority would not be the Prime Minister of the day would not be informed of the use of a delegated authority.
They wouldn't be informed about the delegation. It's the actual that the Prime Minister would then look at the case afterwards, not to second guess it, obviously, because it's already been agreed. But we were suggesting that, as a matter of course, the Prime Minister should afterwards then be informed of the actual contents of that warrant. And for some reason, the government's resisting that, and I can't understand why.
If my answer wasn't clear, I understood the point he was making, but I would suggest it was inconceivable the exercise of this power would not then be routinely informed to the Prime Minister. But ultimately, that is a level of granularity that adds complexity to the bill without necessarily utility. But as I say, through the passage of the bill thus far, we have listened carefully to the suggestions that the committee has put forward, and whilst if we don't always agree, I can reassure him and the other members of the committee and the members of the House that we will continue to act in a listening mode to the suggestions put forward by the committee. I will, but I do want to make some progress.
Thank him for giving way. He's mentioned listening to the scrutiny by the ISC. The Joint Committee on Human Rights, we've also issued a call for written evidence on the bill. And of course, as he knows from the Human Rights Memorandum, the bill raises important human rights issues relating to the right to privacy, freedom of expression, and possibly also the right to an effective remedy. So will he undertake to look closely at any correspondence the Joint Committee might send him when we've completed our scrutiny of the bill?
I can assure the Honourable and Learned Lady that we will do exactly that. We will do exactly that. Turning now to the measures in the bill, we are creating a new regime for bulk personal data sets that have low or no expectation or privacy. For example, certain data sets that are widely publicly or commercially available anyway. Bulk personal data sets are an essential tool to support our intelligence services in identifying fragments of intelligence within a large quantum of data, in order to disrupt the threats such as terrorism and hostile state actors. The bill seeks to create a new statutory oversight regime for how the intelligence services access and examine bulk personal data sets held by third parties. This places this oversight on a statutory footing, increasing the transparency of the regime. And the regime will be subject to strong safeguards, including the double lock. We're also making changes to the notices regime that will help the UK anticipate and address the risk to public safety of companies rolling out technology that precludes lawful access to data. We want to work with those companies to achieve common goals, but we must have the tools available when collaboration falls short. There are three types of... I will give you.
I know he wants to make progress, but I'm grateful for the opportunity to comment here. These reforms to the IPA are necessary to upgrade our world-class regime to ensure that our frameworks are kept up to date with evolving threats and, importantly, technology. And I want to jump on the point that he just referred to. We know that the terrorists, the serious organised criminals, the fraudsters and the online paedophiles all take advantage of the dark web and encrypted spaces to plan their terror, to carry out their fraudulent activity and to cause devastating harm to some innocent people, such as children, in the field of online paedophilia. Does my honourable friend share my concern and indeed frustration with certain companies like Meta and Apple, the former that has chosen to roll out end-to-end encryption without safeguards, the latter which has rolled out advanced data protection, which will allow these bad actors to go dark, which will severely disable the agencies and law enforcement from identifying them and taking action, and which will enable and indeed facilitate some of the worst atrocities that our brave men and women in law enforcement agencies deal with every day.
My right honourable friend and immediate predecessor makes incredibly important points. Digital technology, online technology has been a liberator in so many ways, but sadly, as is the case with technology throughout time, it has also been used by those that would do people harm, and indeed she mentions particularly the harm done to children. We take that incredibly seriously. We value the important role that investigatory powers have. We will continue to work with technology companies, both those well established at the moment and those of the future, to ensure that we maintain the balance between privacy and security, as we have always done, but ensure that these technology platforms do not provide a hiding place for terrorists, for serious criminals, and those people taking part in child sexual exploitation. The three types of notices under the existing IPA, the data retention notices, technical capacity notices, and national security notices. And these notices must be both necessary and proportionate, and of course are subject to the double lock. The bill does not introduce any new powers for acquisition of data. This is about making sure that the system is up to date and that it remains robust. The bill will create a notification notice allowing the Secretary of State to place specific companies under an obligation to inform him or her of proposed changes to their telecommunications services or systems that could have an impact on lawful access. This is not a blanket obligation and will be used only where necessary and only where proportionate, and only then on a case-by-case basis. The notice does not give the Secretary of State any powers to veto or intervene in the rollout of a product or services. It is intended to ensure that there is sufficient time for appropriate consideration of the operational impacts and potentially for discussions with the company in question about the proposed changes. The public rightly would want their representatives to know in advance if companies are proposing to do something that puts public safety at risk. And responsible companies will, of course, work with governments to avoid endangering people. Those people are, of course, also their customers. The bill also amends the IPA to require the company to ensure that existing lawful access is maintained. This means that the company cannot legally take any action that will negatively affect the level of lawful access for our operational partners during the review period. In the other place, the government tabled an amendment to allow for a timeline for a review of a notice to be specified in regulation. We also gave the Judicial Commissioner further powers for managing the review process. Taken together, these ensure companies are clear on the length of time that a review can take, which reduces uncertainty for their business, as well as providing greater clarity for the process of review. My noble colleague, Lord Sharp of Epsom, in the other place, also committed to a full public consultation before amending the existing regulations relating to the review of notices and laying new regulations relating to the notification notices. The bill also clarifies the definition of a telecommunications operator to make clear that companies with complex corporate structures that provide or control telecommunications services and systems in the UK fall within the remit of the IPA. These changes do not directly relate to any particular technology, including end-to-end encryption, but they are designed to ensure that companies are not able to unilaterally make design changes which compromise exceptional lawful access. The bill makes changes to the powers of public authorities to acquire communications data. Section 11 of the IPA made it an offence for a relevant person within a relevant public authority to knowingly or recklessly obtain communications data from a telecoms operator or a postal operator without lawful authority. The bill will set out examples of the acquisition routes that amount to lawful authority outside of the IPA, giving greater clarity to public authorities that they are not committing inadvertently an offence. Further targeted amendments will ensure that public sector organisations are not unintentionally prevented or discouraged from sharing data. And further changes will allow bodies with regulatory functions to acquire communications data. The bill also creates a new condition for the use of Internet Connection Records, ICRs, by the intelligence services and the National Crime Agency. The IPA currently requires certain thresholds to be met on the known element of an investigation, such as exactly when a website has been accessed. This limits the ability of operational partners to use the ICRs to detect previously unknown criminals, terrorists, or state threat actors who are acting online. The proposed measure will allow greater detection of high-impact offenders by removing the requirement to unequivocally know a specific time or times of access and service in use, and instead allow these factors to be specified within the application. Please.
Yeah, I mean, I understand the use of this to the security services, but it also broadens the scope of how many people could drag into this measure, and there is no judicial oversight in terms of before the security service or whoever's using this, and also it talks about in the bill that it's for national security and economic well-being, and I've got to say I think this is a catch-all for quite a lot of things. And I think although the intent is right, I think there needs to be at least some safeguards that innocent people are not being dragged into this quite broad, potentially broad measure.
I understand the point the honourable gentleman makes. I mean, within data set capture, innocent people's data is often acquired and is always deleted. And with regard to the economic well-being, that merely reflects the language that's used in other parts of this for consistency across the various strands of the work that we do.
I thought we were here today to actually scrutinise this bill, not think it was a chore on behalf of the Home Secretary to have been asked questions. But the definition in terms of well-being could be quite broad. I understand, I think he does, and the House would, national security. This well-being could be quite a broad definition, and I'm not yet convinced that I've yet seen what that is. If it's just that it's a bit of consistency in this legislation to another piece of legislation, I'm not sure that's a great argument for actually including it in this piece of legislation.
I disagree with him, is the simple truth of the matter. I think with legislation of this nature, and particularly with regard to clarity of intent, maintaining consistency of language with previous relevant pieces of legislation, including the 94 Intelligence Services Act, for example, I think is incredibly important. But as I say, I recognise that he has given thought to this, and we don't disregard the points he's made, but we have thought through the importance of consistency of language, which is why we maintain the consistency of language. Where were I? Please.
Thank you for giving me on that point. I think that a general listener to our proceedings might worry that the new powers might be used for fishing expeditions rather than the very specific powers that they replace. So could he give them some words of reassurance from the dispatch box that that broadening of bulk data collection without the specific dates isn't going to be used for fishing expeditions, which might affect the privacy of ordinary citizens who've done nothing wrong?
I mean, the Right Honourable Lady makes, I think, an important point, but it's a point that could be applied to any bulk data set collection of which she knows there are many across government. And there are provisions in place to ensure that the data of innocent people are not held, that the data are deleted, and that our security services and the other organisations that will utilise these powers always do so carefully and cautiously. And of course, there are safeguards in place that I've made reference to with regards to the Investigatory Powers Commissioner and the Tribunal if there is wrongdoing. So there are safeguards in place, and they are relevant. The proposals are put forward for a very specific reason. And we've given thought to kind of mission creep and broader expansion, and the government feels that this is a modest extension that will actually give significantly greater protection to the British people.
I mean, one of the things that I think, if what my honourable friend has just said, we need to give confidence to the public that what we're actually doing quite rightly to protect our security has that level of security in it. And on internet connection records, there is no judicial oversight of that process. So isn't it the fact that if we are going to give these powers to the security service, which I approve of, that to ensure that we can say to the public that these are proportionate, and also that there is an independent process into ensuring that these can't be abused, surely judicial oversight throughout this should be an important thing.
I mean, I noticed he was quite specific saying about judicial oversight, but the point is there is oversight. There is oversight. There's oversight by the Secretary of State through the warranty process. There's oversight of the whole process by the Investigatory Powers Commissioner. There is oversight of the Secretary of State function through the committee on which he sits. So there is oversight.
I agree, and that's why I support that oversight, even though I've got to say this government doesn't make our job very easy on the ISC. But on the internet connection records, there is no, as I'm reading the bill, unless I'm missing something, there is no judicial oversight of that process. And that's what I'm saying, is if we actually want to give people confidence, having that backshop of judicial oversight should be the important thing.
No, as I said, I noticed he was specific in saying there is no judicial oversight. The point I'm saying is I'm not disagreeing with him. The point I'm saying is there is oversight. There's more than one, and indeed the committee on which he sits is part of that oversight process. I will give way on that.
Grateful. And he has just touched on the importance of the oversight role of the ISA, particularly in relation to these additional provisions. I just wonder if he remembers the passing of the National Security Bill. We're actually in the final stages of that important piece of legislation. The government tabled an amendment in lieu, promising that it would progress a review of the Memorandum of Understanding within 6 months of the National Security Bill coming into force to make sure that there was an updated and robust relationship between the government, the Prime Minister in particular, having been unable to secure a meeting between the ISA and the Prime Minister since 2014. Remarkably, I just wondered, given the nature of the ISC's important role in these provisions, if you could give us an update on where that review has got to.
That's not an element of this bill. So no, in terms of the commitment for the Prime Minister meeting with the committee, I'll look at the details with this. But I will make progress, because I want to make sure that everyone who wishes to speak in this debate is able to do so. But I will give way to the right under it.
Just on that point, will the Home Secretary encourage the Prime Minister to go before the Intelligence and Security Committee at the soonest opportunity? Because my understanding is it hasn't happened for 10 years.
Well, I can't commit the Prime Minister to... I can't make a commitment on his behalf. Members of the committee will know that certainly in my previous role, I appeared before the committee. I think it's important that the government does make itself available for this. As I say, it would be inappropriate for me to demand of the Prime Minister attendance anywhere, but I will absolutely pass on the Right Honourable Lady's point.
Just to assist the Home Secretary with a little context, when I was previously a ranking member of the Intelligence and Security Committee between 2010 and 2015, it was a matter of routine that once a year the committee went to see the Prime Minister, usually in the Cabinet room. This stopped in 2014, and successive Prime Ministers have failed to reinstate it, although it must be said that the shortest lived of them did offer to meet with the committee, but sadly ceased to be Prime Minister before that became possible.
The length that some people go to avoid committee scrutiny. I'm trying to remember where I was. It's been such a long time since I looked down the page of this speech. Where are we? Proposed measures will allow greater detection of high-impact offenders by removing the requirements on... I've done that. All such applications must be necessary and proportionate and subject to independent authorisation or independent inspection. The bill will also strengthen safeguards for journalistic material within the Investigatory Powers Act bulk equipment interference regime, aligning it to changes to the bulk interception regime which are underway to ensure compliance with obligations under the Human Rights Act 1998. Prior judicial authorisation will be needed before material obtained through bulk equipment interference can be selected for examination using criteria where the purpose is to identify or is highly likely to identify confidential journalistic material or confirm a source of journalistic material. Prior judicial approval is also necessary before such material may be retained for the purposes other than its destruction. The other measures in Part 5 of the bill will ensure that the resilience and protection of the regime are maintained and enhanced. The bill also makes improvements that will support the Investigatory Powers Commissioner in effectively carrying out their role, ensuring that the world-leading oversight regime remains resilient. This includes powers to enable the IPC to appoint deputies, delegate some of their functions to judicial commissioners, and the newly created deputies, and put certain functions on a statutory basis. The bill will ensure there is a clearer statutory basis for reporting errors to the IPC. Mr. Deputy Speaker, this bill brings the Investigatory Powers Act up to date.
I'm grateful to him, a sense that he's coming to the end of his speech, and I just want to raise another important group, because we've mentioned parliamentarians and journalists. I want to talk about trade unions, because some people fear that this bill will open the door even further than its parent bill on the surveillance of trade unions. And I wonder whether he will agree with me that there should be no place for the surveillance of trade unions in a democracy. And if he agrees with that, will he consider amendments to the bill to make sure it doesn't happen, including a redraft of Clause 5?
I will take the point that the Honourable Lady puts forward. I think there are a number of organisations that are not explicitly mentioned in the bill where that argument could be made, and I'm not sure it would be necessarily useful or right to list them all. But I will take on board, and genuinely in good faith, the points that she makes. The bill brings the Investigatory Powers Act up to date with the modern age, provides greater clarity, makes the system more resilient, and retains the world-leading safeguards of civil liberties and commercial integrity. And above all, it will mean that the men and women who work often without recognition, but who work so incredibly hard to keep us safe, have the tools that they need to do so in the modern era. And I therefore, Mr. Deputy Speaker, commend this bill to the House.
Yeah. Question is that the bill be now read a second time. Opposition front bench, Yvette Cooper.
Yeah.
Thank you, Mr. Deputy Speaker. The first duty of any government is to keep its citizens safe, to defend our national security, to defend our citizens against terrorism, extremism and serious crime. And on national security, Labour always stands ready to work cross-party to keep our country safe. It's why Labour is supporting this bill today, while we will work with the government to get the details of it right and look forward to pursuing some of these issues further in detail in committee, and to recognise too the important work that the Intelligence and Security Committee has done on this, that Lord Anderson has done in reviewing these areas, and I pay tribute to his work and his previous work as independent reviewer, and to the detailed considerations that have already taken place in the House of Lords as well. It's vital that our intelligence and law enforcement agencies have the powers and capabilities they need to pursue terrorists and dangerous criminals such as child abusers, and to keep the public safe. And I want to pay tribute to the work of the intelligence and security agencies and our counter-terror police as well, for the immense work that they do. We're all indebted to them for their tireless and, by necessity, often hidden work to protect our country and to defend our democracy and our freedoms from those who would seek to do us harm. And it's significant in the context of this bill that their work is not just about protecting our security, but to defend our democracy as well. And that's why it's so important that the powers that those agencies possess and operate within a clear and strong legal framework, with proper oversight and with robust safeguards to prevent abuse or misuse. It's why the agencies themselves support having the strong legal framework in place. It's how we ensure there is consent and support for the essential work that they do. It's why this framework has to protect both privacy and protect us against serious threats. Why it has to defend both security and liberty, because in a democracy those go hand in hand. Strong powers always need to be accompanied by strong oversight and strong safeguards, and that is why it's important we get the detail right. So just as we worked in a constructive cross-party manner on previous investigatory powers legislation and also on the National Security Act, we will continue to do so on this legislation as well. The reality that we all face is the threats to our national security are now more complex than ever. The fast-changing challenges from homegrown extremism and radicalisation, the steep rise in state-sponsored threats from hostile foreign actors, as well as the exponential growth in new technologies and the proliferation of serious crimes as well as national security threats such as child abuse being perpetrated and spread online that puts young children and young people at terrible risk. So within that rapidly evolving landscape, we obviously cannot allow our security services to be outpaced. We have to ensure that the interception powers that security services and our police have to fight crime are updated to cope with rapid technological changes and changing threats as well, but also ensure that the safeguards, the oversight also keeps pace too with the changing powers, so that we continue to ensure, as is embedded in the legislation, that all measures are appropriate and proportionate when action is taken. That's why we rightly have in the existing IPA measures such as the double lock on some of the measures around the Judicial Commissioner's approval and oversight as well. But those too need to be updated in response to changing technology. Mr. Deputy Speaker, this bill is necessary because technology is moving so fast. We have now the serious crimes of child abusers using new and very different methods to share vile images of sexual assaults on children. Extremists and terrorists using different and changing internet fora and encrypted messaging to find new ways to radicalise and organise, and serious and organised criminals using new applications to launder money and drugs and facilitate organised immigration crime that can put lives at risk as well. So clearly, that means the legislation needs to be updated as well. And that is why we recognise the need for measures, some of the main provisions in the bill, for example, on bulk data sets, recognising the need for the government to make changes to the existing framework because agencies who are working at pace to intercept threats should not have to go through the same lengthy processes to use data sets which are themselves widely available to the public and to other commercial organisations. In the other place, in the Lords, members did their debate the importance of getting the threshold right and what the way in which the phrase low to no expectation of privacy should be interpreted. I know that those discussions will continue rightly at committee stage here, and we will also continue to seek further clarification on some of the interaction of these reforms with some of the measures in the Data Protection Act as well. On the issues around the internet connection records, again, the bill does reflect some of the recommendations that were made by Lord Anderson. This is a sensitive area, and rightly there is a high test for enforcement agencies to meet in order to access vital records, but there also are particular concerns around child abusers and terrorists being able to use new fora and communication channels where there should be further ability to pursue action, to pursue intelligence leads as well. And so we recognise the importance of this issue, but also of making sure that we get it right and frame the detail in the right way to ensure that we can protect vulnerable young people and children. Ministers are right, too, to ensure that government departments aren't inadvertently prevented from the kinds of normal and routine legitimate exchanges of basic information by inadvertent coverage of previous legislation as well, but again, making sure that there are the appropriate safeguards in place. And we also agree that it is important that there are processes to ensure that security and intelligence agencies can anticipate technological changes that are coming down the track from major telecommunication companies, major commercial organisations, which might potentially make their work more difficult or put national security at risk inadvertently. And rather than have everyone simply try to play catch-up in retrospect, including with criminals and terrorists who may exploit those changes, having a process for a constructive dialogue between companies and intelligence agencies in advance to mitigate any adverse consequences for tackling serious crimes like child sexual exploitation is sensible. And I hope that ministers will look at how far they can ensure that regulations to govern changes to the notices regime are properly consulted on and scrutinised to ensure that they are set at the appropriate level as well, and continue to engage with technology companies in how those should be implemented. We also welcome the additional safeguards being introduced and some of the stronger oversight being introduced, including as a result of some of the discussions that have taken place in the Lords. For example, ensuring that that more of the Commissioner's functions are put on a statutory footing. For example, too, ensuring that there is proper oversight of the use of third-party bulk personal data sets by intelligence services, and also the Government's Amendment 45 in the other place to include additional protections in relation to confidential journalistic material and sources of journalistic material. And again, we hope that is an issue that can be looked at further at committee stage in this place as well. But I would also, in the context of what the oversight arrangements should be, ask the Government to look again at the role of the Intelligence and Security Committee. As a former member of the Intelligence and Security Committee, though it was now more than 2 decades ago, I can testify to the importance of the committee and also the seriousness with which all of its members take their work. They provide a level of oversight and scrutiny that, of course, cannot be provided in the normal way by other parliamentary select committees, by the nature of the secret work that our intelligence agencies need to do. And they also, I believe, perform an important role for government as well. They should be the reassurance for ministers that the work of the intelligence and security agencies is being appropriately scrutinised. And therefore, I think the government does need to look again at the need to update the Memorandum of Understanding for the Intelligence and Security Committee to ensure that it too can fit with the evolving landscape and the changes that are taking place, and to make sure that its remit can do so as well. And I would just press him again. I do understand he cannot answer for Prime Ministers in a simple way, but I would press him to take back to the Prime Minister. I think this is important to recognise the serious role that the Intelligence and Security Committee plays, that is not something that is simply about the role of the Foreign Secretary, the role of the Home Secretary. It is also about the role of the Prime Minister, because there are powers that only a Prime Minister has and has to execute, as we reflect in this legislation, and therefore recognition from the Prime Minister of the role of the ISC, I think, will be important as well. Finally, there is obviously the complicated issue that Lord Anderson also raised about the circumstances in which the Prime Minister's unique powers can be delegated in the context of intercept warrants targeted at members of relevant legislatures. And there was a detailed discussion. Those warrants are rightly subject to a triple lock process, which requires the authorisation of the Prime Minister as well. And We recognise the experience of COVID and the hospitalisation of the then Prime Minister in 2020 did give rise to questions about what should happen in those circumstances and making sure that there were proper procedures in place for those circumstances to ensure that there was no national security gap. I think the members of the other place were right to press for tightening of those arrangements as well. It does, however, raise, of course, wider issues that actually this bill can't address, that around what happens should there be a conflict of interest for a Prime Minister, or should there be circumstances in which a Prime Minister is accused of being careless on issues around national security. I don't think that can be addressed by this legislation or perhaps by any legislation, but it is a salutary reminder to all of us of the importance of Prime Ministers taking immensely seriously their responsibilities towards our national security and always behaving in a way that means that that can never be in doubt. Mr Deputy Speaker, this is an issue that should be a cross-party one, that should be a matter for all of us to work together. I know that individual members in this chamber this evening who have great expertise in this area will want to raise further questions about the further details, application of this legislation, and I hope that those will be considered in the same spirit that we had in the House of Lords, will be considered in the House of Commons. Very often in this place, the government simply maintains its position and the detailed amendments take place in the Lords. I hope that on this issue, the same spirit of cross-party discussion that has taken place in the Lords will take place here. Yeah. This, in the end, is about ensuring that there is proper oversight, that there are proper safeguards in place, but it's also vitally about defending our national security at a time of rapidly changing technology, when all of us have great concerns about the potential for terrorists, for extremists, for serious criminals to exploit that new technology to do all of us harm. We have to make sure that all of us are vigilant and that we make sure that the agencies, the intelligence and security agencies, are supported to be able to do the work we need them to do on our behalf, which is to keep our country safe.
Sir Jeremy Wright.
Thank you very much indeed, Mr Deputy Speaker. And I want to say, first of all, that I am in favour of this bill. I think it's a sensible updating of the intelligence community's powers in the ways that the Home Secretary has described, and indeed the Shadow Home Secretary has described. I also am in favour of the principle that the Shadow Home Secretary mentioned, which is that greater powers for the intelligence agencies should come with greater oversight of those powers. And I know that my colleagues on the Intelligence and Security Committee will want to focus on some of the areas that this bill covers. I want to focus my remarks on internet connection records, which are, of course, important pieces of intelligence. We're talking here about which internet sites were accessed and when, not, of course, precisely what was viewed or what activity was carried out. But nonetheless, these can be of significant intelligence value. And the 2016 Investigatory Powers Act allows for the obtaining of internet connection records data in certain circumstances. The circumstances I want to concentrate on, Mr Deputy Speaker, are where an intelligence agency is focused on the use of a particular internet service at a particular time and are keen to know the identity of the personal persons who have been using it at that time. Now, that's covered by Section 62 of the Investigatory Powers Act of 2016, which gives authority for an intelligence agency to obtain that information. This bill, of course, seeks to broaden an agency's power to act in those circumstances. And the law currently requires the agency to know specifically which service has been used and specifically at which time it was used. Clause 15 of this bill seeks to extend that to allow the collection of ICR data to identify individuals using one or more specified internet services and in a specified period. Now, of course, what that means, Mr Deputy Speaker, the bill is currently drafted at least, is that there is no apparent limit on the number of internet services which can be specified or on the length of the specified period. So this clause could allow an intelligence agency to collect ICR data on a large number of different internet services and over a long period of time. That would inevitably involve data on the activities of a potentially large number of people, as opposed to the current law, which permits only examination of, as they say, a specific service at a specific time, which carries, of course, much less risk of other wholly innocent and uninvolved individuals being caught in the net. Now, I do not suggest, and neither, I think, does the Intelligence and Security Committee, that the intelligence agencies do not need these wider powers. We do say, however, that this is a significant widening of their powers and that it should therefore come with additional scrutiny from a judicial commissioner. Now, in response to that, I think we can deduce from not just the debate in the other place, but what the Home Secretary has said in this House and what other ministers have said at other times, that the government essentially makes two arguments. The first argument they make is that this new power is not intrusive enough to merit extra oversight, as ICR data relating to those not subject to agency interest is not retained. And secondly, that the power proposed is no more intrusive than current powers to collect internet connection data. Well, on the first of those arguments, the fact that data is not retained does not, of course, mean that it's not intrusive to collect it. Many of our constituents would be concerned that their internet activity is being scrutinised, even if no action is taken thereafter. And we should, Mr. Deputy Speaker, keep in mind that the Bill's language does not limit that scrutiny to sites visited which are inherently suspicious. Even everyday online activity may be of interest in the case of individuals of concern, but this provision would mean that the everyday online activity of many who are not of concern will also be examined. And that, we say, makes the provision worthy of additional oversight. Second argument the government might make is that this is no more intrusive than current powers. Well, that I think is true in terms of the depth of the intrusion. It is still the when and where of internet activity rather than the what that we're talking about, but it's not true in terms of its breadth. Many more people will be caught by it, and that is a significant and material increase in intrusion for the population at large. So we do, Mr. Deputy Speaker, believe that the government should think again, not about whether intelligence agencies should have these wider powers, but about whether there should be the involvement of external scrutiny to make sure they are used properly. Mr. Deputy Speaker, there's only one other matter I want to touch on briefly, and it's been mentioned already. That is the grounds on which powers such as these can be used, and they are essentially three. First, in the interests of national security, no argument with that. Secondly, in urgent cases to combat some forms of criminality. But thirdly, in the interests of the economic well-being of the UK, insofar as those interests are also relevant to national security. And the last of these, as the House knows, has long been controversial as an appropriate ground for action. And the more intrusive the powers that can be used with this justification, of course, the more controversial it is. I think it is fair to say, Mr. Deputy Speaker, that the ISC is concerned about its use here, and the House will want to consider, I'm sure, as this bill proceeds, that its application to these powers and more generally is still appropriate.
Indeed, Mr. Deputy Speaker. And can I also start with two thank yous? First of all, I put on record my party's gratitude to the intelligence services and law enforcement organisations that do work incredibly hard to keep all our citizens safe in the face of constantly changing and developing threats. Secondly, my thanks also to all those who took part in the reviews of the 2016 Act that have informed this bill. However, as Lord Anderson said himself in his review, these should be a starting point for parliamentary scrutiny and debate and not a finishing point. And while any opportunity to revisit and improve the Investigatory Powers Act would generally be welcome, my party does have some serious concerns about certain provisions in this amendment bill. In short, while it is constantly presented as an updating and protection and making efficient of pre-existing powers, we fear that the reality is a very significant expansion on what are, we have to remember, already extraordinarily wide powers by international standards. There are significant privacy and human rights risks here, and the danger of increasingly widespread suspicionless surveillance. We fear we may be handing invasive powers to intelligence and law enforcement, not because the powers are essential or necessary for their work, but because they are convenient, and that is not striking the right balance. And all of this is consistent with the very detailed and principled privacy and human rights concerns that my party raised in relation to the 2016 Act itself, particularly, I may say, in the speeches by my honourable and learned friend from Edinburgh South West, who is here to take part in the debate again today. And as will be the case today, we did not oppose second reading of that bill, but absent important amendments or concessions and reassurances, again, like the 2016 Act, we do keep open the option to oppose the current bill at a later stage. So today I will focus on concerns relating to bulk personal data sets and also to notices relating to changes to telecommunication services. I'll also briefly flag our concerns on internet connection records and changes to the offence of unlawfully obtaining communications data. My party also believes that this bill provides an opportunity to revisit the whole issue of snooping on parliamentarians if we are bold enough to take it. So turning first to bulk personal data sets and Part 7 of the 2016 Act. In short, we struggle to see that these proposed changes have been shown to be necessary, but fear they will instead see even larger gaps in the oversight regime in relation to these capabilities. A whole host of concerns arise in relation to the provisions of Clause 2 and the concept of data in relation to which there can be low or no reasonable expectations of privacy. Bluntly, Mr Deputy Speaker, I struggle to see how a decision maker is supposed to assess people's reasonable expectations of privacy. And by people, we can be talking about hundreds, thousands, potentially even several million people. Within that group of individuals, there will be many varying attitudes to further privacy. And the data related to the individuals could vary hugely from the mundane to the deeply personal. It may be that there's supposed to be some type of reasonable person test applied. But is that reasonable person black, gay, Jewish, or indeed a trade unionist? How are potentially very different subjective attitudes to be accounted for? These may seem like some odd questions, but experience from the United States of America, where a similar test is involved, prove that these questions are very, very real indeed. Is it a general question of privacy in relation to the data, or a more specific question of expectations of use of that data by intelligence services? What precisely is low expectation? It just to me seems to be an impossible assessment to undertake in any realistic or meaningful sense.
On that point, will he give way?
Of course.
Yeah. Thank him for giving way and for his kind comments earlier. As usual, he's making a very forensic speech. On this issue of reasonable expectation of privacy, does he agree with me that Clause 2 and indeed 11.3 seem to be based on a legal misunderstanding that people lose their right to privacy when they happen to share certain information with someone else? He will be as aware as I am that that runs contrary to the jurisprudence of the European Court of Human Rights. And by contrast, the Court has actually said that privacy includes, and I quote, the right to establish and develop relationships with other human beings. And does he agree with me it's very important that we make sure that this bill is commensurate with our obligations under the European Convention on Human Rights?
I'm very grateful for that intervention, and my honourable friend will not be surprised to hear that. I completely agree with her. And in fact, it brings me on to the next points that I want to raise in relation to Clause 2. So as well as putting in place what I struggle to see can be a reasonably operated assessment, it does raise concerns in relation to both consistency with data protection legislation and indeed human rights obligations. Because, first of all, the factors to be taken into account when undertaking that really difficult assessment do not even expressly include the sensitivity of the data in question, which surely should be central to any question of processing. And that is an inconsistency with current existing data protection principles and laws, and I agree absolutely the compatibility of such provisions with our human rights obligations is surely also highly dubious. Just because someone has shared personal data does not mean that they automatically lose their right to further protection around how that data is shared and processed, especially when that is sensitive personal data, the point that my honourable friend has just made. Here, the role of judicial commissioners is even further diluted, reduced to reviewing by judicial review standards whether data sets do indeed relate to data where there can be low or no expectations of privacy. That, Mr Deputy Speaker, is frankly not really a safeguard at all. So at the very least, as we go through committee, their role needs to be strengthened. And we also need to seek assurances around how this will impact on the reporting of retention and use of bulk personal data sets. Because if large numbers are being retained under category authorisations, we may not know in actual fact how many data sets are actually being gathered. Mr Deputy Speaker, turning to various aspects of Part 4 on notices, again there are some controversial provisions here, and that's particularly the case with Clause 21 and the requirement on selected telecommunications operators to inform the Secretary of State if they propose to make changes to their products or services that would negatively impact existing lawful access capabilities. Mr Deputy Speaker, to me that seems like an extraordinarily broad power, without anything remotely appropriate in terms of oversight and limitations. Again, these powers are going to make the UK a real outlier. Essentially, the Secretary of State is empowered to say to tech companies, you're not allowed to improve your products without consulting us, so that we can still break in to access the data that we need and when we want it. And despite what the Secretary of State says, taken together with other changes to review processes, such powers could easily be used to significantly delay or, in effect, de facto veto updates to security, rendering everybody's data more vulnerable to hacking by third-party actors. Yes, I'll happily go to the Minister.
That is simply incorrect, and I know he wouldn't wish to continue down a road that he knows to be incorrect. So let me just be very clear. This is a continuation of a power that was granted in 2016. The notice does not extend that power, but merely enables a conversation to begin with companies before any action is taken to maintain an existing standard and not, in fact, to change it.
Well, I'm very grateful for that clarification from the Minister, and we will, of course, engage further in this debate on the committee. But these are concerns that have been raised not just by me, but by significant tech companies. So, this is not something that has just come to me through perusing the bill. These are concerns that have been raised by significant tech companies. But the key question remains, why is there to be no proper oversight of these notices and the notice powers via independent advance authorisation? Why is there not even the double lock that applies to other notices that can be served on communications providers under that Act? Surely there should be that scrutiny in advance. And there are also lots of question marks around the expanded claims of international jurisdiction. How will potential conflicts of law be resolved, especially if a company subject to one of these notices, which is contrary to its domestic laws, can't actually even say anything about it because they're bound to secrecy by this legislation? What are the prospects of other governments copying what our government is doing, seeking to replicate this, and what would the impact of that be on UK companies? Turning to internet connection records, I think the starting point here is that we should remember that no other European or Five Eyes country permits the requiring of ICR generation or retention in relation to their own residents. So these were a hugely controversial development in the 2016 Act. ICRs, as we've heard, can reveal huge amounts of deeply sensitive information about a person. For now, secret services, as we've heard, can only seek ICRs where certain facts are already known, such as the identity of a person connecting or the time and use of a connection, so the retention is at least targeted in some way. The risk in this bill is that no longer will we have reasonable suspicion precede targeted surveillance. Instead, the bill would seek to use ICRs for discovery of new targets, which is a really significant jump in development. And I can genuinely understand some of the reasons being offered for this change, and I'm not unsympathetic to the case being made. But if these powers are not very carefully circumscribed, such powers risk a big step towards mass surveillance and phishing exercises. We need to ask whether there are less invasive alternatives and whether these powers therefore are really necessary. Alternatively, as already been argued for, we need to look again at the oversight mechanisms for use of these powers. Mr Deputy Speaker, we also have some concerns about what the bill proposes in relation to the offence created by the 2016 Act, where relevant persons in a relevant public body knowingly or recklessly obtain communications data from a telecoms or postal operator without lawful authority. So this bill seeks to set out some examples of what would amount to lawful authority, a laudable aim. However, there are real questions over whether some of the examples in Clause 12 of this bill are not in actual fact redefining the concept of lawful authority. In particular, again, going back to the point that my honourable friend made, the assertion that there is lawful authority simply because the communications data has been published before the relevant person obtained it is controversial. And that's particularly so when publish means make available to the public or a section of the public, whether or not on a commercial basis. As I said in relation to bulk personal data sets, limited publication is not authority for intrusive surveillance. Could a simple private message not amount to publication of comms data? The implications of this definition of lawful authority really need very careful scrutiny indeed.
Here.
Finally, Mr Deputy Speaker, on the interception and hacking of parliamentarians, making provision for circumstances where the Prime Minister is unavailable to play his part in the triple lock seems sensible. But the fact the issue of snooping on MPs and others is being revisited should trigger us all to rethink the whole scheme. Our role representing our constituents, interrogating legislation and holding the government to account should not be interfered with lightly. We should take the chance to consider post-surveillance notification of MPs who are being spied upon by judicial commissioners once investigations are completed, because as matters stand, redress is, at the moment, almost impossible to obtain. We should also require that investigatory powers commissioners be informed every time that these powers are being used, so there is transparency about how often this is happening. All other options should be on the table as well. Mr Deputy Speaker, I started by thanking intelligence and law enforcement authorities, and I'm happy to do so again in closing. But our respect for them does not mean we should ever consider writing blank cheques or handing them whatever powers that they ask for. They are not perfect. From time to time they exceed their powers, while certain individuals abuse the lawful capabilities that they have. The powers they seek through this bill are extremely invasive and broad in scope. There is a real danger that key provisions of this bill go beyond what is necessary and gets the balance of privacy and human rights wrong. These provisions will need serious scrutiny and revision in committee, and that is what we in the SNP will seek to secure.
Hear, hear, hear.
Sir John Hayes.
Thank you, Mr Deputy Speaker. Hegel said, what is reasonable is real, and what is real is reasonable. And it is certainly reasonable in facing the very real threats that pervade, that we equip those missioned to keep us safe with the powers they need to do so. And that is in part about putting into place a legislative framework that allows them to counter those threats. For we know what happens when they don't. Well, we sit in this chamber, graced by the coat of arms of our former colleagues, Joe Cox and David Amos. We know in this place what it means when those missioned to keep us safe aren't able to successfully do so. On that basis, I was proud and pleased to take the original Investigatory Powers Bill, now the Act, through this House. There are some veterans of those events in the chamber tonight, Mr Deputy Speaker. And in doing so, I was conscious, we were conscious, I may say, that there was a need to strike a balance between providing those powers and equipping the police and the security services with the necessary mechanisms to do their job, and on the other hand, retaining both the privacy of individuals and putting into place the necessary state safeguards that were mentioned by the Shadow Home Secretary. That balance between privacy, it's been referred to already, was at the heart of our consideration then. Indeed, drawing on some of the debate that took place at that time, I'm conscious that I said it's important to understand that privacy is the very core of the then bill, now an Act. The protection of private interests, the protection of the public, are the heart of all we seek to do. That remains so, but it's important also to recognise that we always anticipated that the legislative arena of a kind that we're discussing this evening was bound to require a dynamic approach, that we would need to update the legislation to deal with the changing character of the threats I described. So it comes as no surprise the government have introduced legislation to do just that, to add to what's already on the statute book and to make it more appropriate. More appropriate. I happily give way.
To him for giving way, and we did cross swords often on the passage of the previous bill, but since then we've reached a point of rapprochement, I think, in discovering our mutual passion for the importance of freedom of expression. And I think we can also agree from what he's saying this evening on the importance of privacy. And of course, that comes from the right to a private and family life under Article 8 of the European Convention on Human Rights. So will he agree with me that it's unfortunate, given the huge implications this bill has for the privacy of our constituents, that the government's decided not to conduct a privacy impact assessment? Surely that's something that's absolutely vital here, and perhaps something upon which he and I can again rather unusually agree.
Well, agreements, Mr Deputy Speaker, are becoming rather less unusual. I don't know whether that gives the honourable lady any pleasure or perhaps brings her pain, but nonetheless, she's right that it's important when we consider legislation of this kind that it's scrutinised to an even greater degree than we would normally expect in this place. So the current Act as a bill was considered by 3 committees of this House, was subject to pre-legislative scrutiny by a joint committee of both Houses of Parliament. Indeed, bulk powers, mentioned again earlier in our consideration tonight, was subject to an independent review by the then David Anderson, now elevated to become Lord Anderson. So she's right that the need for scrutiny is profound, particularly when we're equipping organisations with the kind of extensive authority to invade private space. Of course, the truth is that we won't know much of what they do. Many of the individuals involved in the security services and the police and the work they do are rightly unknown to all but a few. So it's all the more important that in giving them that authority, we behave in the way the Honourable Lady described. So, again, I'm adding now to the coalition which we formed between the small coalition. It's a 2-person coalition, actually, that is emerging between she and I. So it's right, as I said, that the legislation is updated to make it fit for purpose. And the ISC, of which I'm proud to be a member too, has been told that is because of the need for urgent, targeted alterations, changes that were necessary. So when we consider the bill before us tonight, we should test whether its provisions are indeed urgent, targeted changes that are necessary. And I'm not absolutely convinced that all of what we see before us can pass that test. And I shall say a little more about that when I come to clause 14 and its associated schedule. Now, just by way of background, for the benefit not of anyone in the chamber tonight, for there is more expertise than I could possibly imagine present in the chamber tonight, but perhaps for the wider audience, to say a word about what the current Act does and why, therefore, this bill matters. It provides law enforcement and security services with the vital powers they need to keep us safe, and it does so in a way that is clear and transparent. And what we did at the time we passed that bill into law was to ensure that the mechanisms that provided safeguards were radically overhauled. The double lock, which we put in place then, was at the time unprecedented, an innovation, one might say. But it does, as the Shadow Home Secretary said, do 2 things. It provides the necessary protection that she described, but it also gives the confidence to the security services that what they're doing is not only authorised but checked, and checked in a thorough way. It's good also for ministers to know they have there's judicial oversight involved in the process as well as political oversight. There have been a number of changes since the Act, and those changes have both been to the job done by the security and intelligence services and the police, but also the reason they have to do that job, because the people that seek to do us harm, for their dynamic too. They change what they do, technology has changed as well, and all of that explains why the bill before us tonight is, in broad terms, welcome and necessary. But the powers that I've described are not given solely to the people that I mentioned. They're also given to a number of other public bodies. This was debated at great length when the current Act was considered in this place, as various honourable and right honourable members will know. because these public bodies, ranging from local authorities to the Environment Agency, to all kinds of others, the Health and Safety Executive springs to mind, who have proper legal functions, one's not debating that, are not quite of a kind with the security services and the police. And so to grant them those kind of intrusive powers was always a controversial matter and bound to give rise, and I put this as mild as I can, to some scepticism. Now, for that reason, when the original Act was before both houses, we deliberated on it in great detail and took a very considered and cautious decision to restrict the use of the power because it was considered then by us as I described it a moment ago, intrusive. As a result, the bodies that I've described, public bodies including the Environment Agency, Health and Safety Executive and local authorities, are required to take further procedural steps in order to compel the disclosure of communications data from telecommunications operators. They must obtain either an authorisation under the current IPA, a court order or other judicial authorisation. Regulatory powers in relation to telecommunication or postal operators, or they must obtain the communication data as secondary data as part of a valid interception or equipment interference warrant. So their ability to take advantage of the powers within the existing Act is both limited, particular, and subject to those safeguards. The current bill, the bill before us tonight, seeks to remove that requirement for those further procedural steps in relation to a wide range of public regulatory authorities. Worse still, and I hope the Minister can correct this in his summation, we've yet to learn which those bodies are. We haven't seen a list of the authorities, and I do hope we will get that list, if not tonight, and it's a big ask for him to read it all out in his 10-minute summation, but I hope he will write to the House and perhaps put a copy in the library explaining who those bodies are that will enjoy these powers. The government's argument for removing the restrictions I've set out is that it's that a broader array of communications data now fall into this category of communications data. The definition of it has broadened. That's the argument, and that a wide number of organisations now constitute telecommunications operators. As a result, it's said that the current restrictions prevented some regulatory authorities from requiring the necessary information to carry out their statutory responsibilities. The problem with that is that unless we know what those regulatory functions are, unless we understand which bodies are involved in the supervisory functions, it is very hard for us to know whether you can legitimise the changes before the House. Now, I've no doubt this will be explored in committee. I would be amazed if it wasn't. But it would be really helpful if the Minister were to, ahead of that further consideration, to clarify which bodies are going to fall into this category, to be more specific and particular. As I said, this was highly scrutinised when we last debated these matters. And at that time, and it's been said already, the powers were tied to national security and serious crime purposes only, to avoid impinging on the very privacy that the Honourable Lady and others have mentioned. And for that reason too, Parliament granted these powers to a very limited range of organisations. We should not brush that aside lightly. Colleagues will be aware of various reports of intrusive use of investigatory powers by local authorities and other public bodies. And I don't think the House would be content to reintroduce sweeping powers for an unknown and potentially unlimited number of public bodies when a previous Parliament decided that that was too intrusive. So I would want the Minister to satisfy the House about the necessity of this change, to specify to whom the change will apply, and to reassure that there is no weakening of that core connection between the previous individual and the necessary powers available to do what's legally right. As I said earlier, Mr. Deputy Speaker, this bill is in broad terms welcome. It is important to understand that we need to update the legal framework in which those missioned to keep us safe operate. But I think the bill can, in its scrutiny, be improved. And I simply point this out. When we debated the Act in its original form, we recognised that through scrutiny, the bill could be improved. I hope again that this Minister, one of my successors as Security Minister, will recognise the same as we continue consideration of this important measure.
Dame Angela Eagle.
Thank you very much, Mr. Deputy Speaker. And I, in common with, I think, all other speakers that have made their contributions thus far in our debate on this second reading of the Investigatory Powers Amendment Bill, I'm not going to stand here and say I oppose it, or that these powers shouldn't exist, nor that they shouldn't be updated in what is a very rapidly developing area of technology, which, as many other speakers have observed in their contributions tonight, this area is rapidly evolving. The evolution of technology is creating threats that couldn't have been dreamed of even when the original Investigatory Powers Act was introduced after an ISC report in 2015 on privacy and security. So these issues evolve, but some things stay the same, and that is that in a democracy, it's important that the security services and all of the agencies, be it police or security, are able to be held to account by the democratic structures that are created to make our democracy real. And I think a point that hasn't been emphasised by others today, which I wish to emphasise, is that we're living through an era where authoritarian governments across the world are beginning to challenge the openness of democratic structures and test whether those who live in a democracy have the political will not only to maintain their democracy but to keep it vibrant and protect it from threats. So against that background, where we are being challenged, and we don't have to look much further than Europe and the borders of Ukraine to see how some of those challenges are beginning to develop, we are being asked whether we rate the health and strength of our democracy enough to protect it. And we are also being asked, and that's the nature of the debate we're having here today, to justify the powers that we are giving to the security and police services to our constituents and to those citizens of our country who wish to see their democracy protected, but also wish to have a proper balance between democratic oversight, safety, and the powers that we give our security services to do their jobs. Now, as many have also mentioned, there's a balance between the effectiveness and speed of those powers and the safeguards that this Parliament puts in place in order to ensure that there's proper oversight of the use of them. And we've heard again from the contributions tonight how that balance, that safeguarding, has been developed in law, and we're looking now at some of the amendments to the existing law there in order to update and modernise those powers, to make them more effective, to make them more efficient, to make them easier to use, to make it the case that protecting our security, be it from criminality, terrorism, paedophilia, or state actors that wish to do our country harm, we have to get the balance between safeguards, openness and transparency, oversight, correct, so that we can protect our society and its values, whilst also respecting and protecting the privacy of every individual citizen that enjoys the freedom of living in our democracy. So the bill seeks an expansion in investigatory powers and some of the powers that are available to the agencies to deal with the evolution in this area. And our job, not only in the debate tonight, in security, in the scrutiny which this bill will be subjected to in committee, is to test and ask the appropriate questions about whether the right balance has been struck by ministers and the agencies in the powers, the extra powers that they want to bring in. And I think it's important also just to say, as the newest member of the ISC, that it's important that as the investigatory powers evolve, so the powers of the Intelligence and Security Committee to do its job in these new areas also is properly developed and also, I think, properly resourced, and that I just leave that on the record. I think it's not a surprise to those who've read the Lord's debates that this is an issue. I wanted to also draw attention to a particular area of the bill where there were some amendments agreed in the Lords, and I'm talking about what's known as the triple lock rather than the double lock. And that is the mechanism which protects the communications of members of this Parliament and other relevant legislatures from being arbitrarily intercepted for no reason by agencies, and in fact is part of the protection that one would expect in a robust democracy for those people who are elected to represent their constituents. They have a reasonable expectation, I think, to be allowed to go about their business without being subjected to that kind of intrusive power unless there's an extremely good reason for it. And members will know that the underlying principle is that the communications of members of this Parliament and other relevant legislators should only be intercepted and read where it's absolutely essential to do so in the most serious of circumstances. Now, the Investigatory Powers Act, which this amendment bill will change, Parliament recognised that this was an issue by adding a third layer of safeguards to the approval process for warrants for targeted interception and targeted examination of communications. These warrants are not only issued by Secretary of State and reviewed by a judicial commissioner, that's the double lock, but they're also approved by the Prime Minister personally. As my right honourable friend said from the dispatch box, clearly there is an issue if there is a Prime Minister who is unavailable to do that, and it's important that there isn't a gap in security protection if you have a Prime Minister who's unable to be the third part of that triple lock. So nobody disagrees with the idea that that process should be made more robust. But there's also an issue about quite how wide the power to issue that final approval, which is currently only rests only with the Prime Minister, should actually go. And there have been debates about that in the other place when this bill went through its stages there. So the balance is how does the new bill before us deal with ensuring that the triple lock is robust and doesn't create a lacunae if the Prime Minister is indisposed and unable to issue warrants without that power going too wide. The Intelligence and Security Committee supports the intention behind this, which is to provide resilience around the current arrangements, but also we're seeking, it's important that the Prime Minister is the person that approves these things, which may affect the operations of the intelligence agencies when they're seeking a targeted interference or a warrant that is very, very time sensitive. But there was agreement that in truly exceptional circumstances it may be appropriate for a Secretary of State to temporarily deputise for the Prime Minister. The committee considered that it was important that decisions on this area should only be delegated in the most exceptional circumstances, can only be delegated to a limited number of Secretaries of State who are already responsible for authorising relevant warrants, and we wished that the Prime Minister must retain sight of all warrants relating to members of a relevant legislature. Now, most of this was agreed in the other place, although there's an issue about whether the relevant Secretaries of State, and there can be up to 5 of those, are ones that already issue warrants. I'm happy to.
Right, would my honourable friend also agree with me that I was a little taken aback that the Home Secretary just assumed that once these had been agreed by a substitute, that they would automatically be reviewed then by the Prime Minister. Clearly, that's a big assumption. Doesn't you think it would be better if it was actually on the face of the bill that the Prime Minister should have actual full oversight of these warrants?
Clearly, I think that putting these things on the face of the bill is often an important safeguard, and certainly also I don't understand why the delegation of these powers shouldn't be limited to Secretaries of State who also issue warrants. I don't quite understand. I don't quite understand why there's an obsession with 5 Secretaries of State. You could have 4 and you'd still have robust oversight. I'm happy to give way.
I'm extremely grateful to the Honourable Lady for Wallasey giving way. Is she aware that there is still currently, I gather, in operation a thing called the Wilson Doctrine, where the Prime Minister, Harold Wilson of the day, all those years ago in the 60s and 70s, gave an undertaking to this House that members of Parliament's mail would not be routinely tapped, only in exceptional circumstances. All this triple lock is doing is putting that doctrine onto a statutory footing.
I thank the honourable gentleman for his comment, and obviously, yes, the Wilson Doctrine is on the face of the previous bill, the Investigatory Powers Bill, and we are seeking to tweak it given what happened with the incapacity of a Prime Minister during the COVID pandemic. And so it seems sensible that one would want to tweak it, but tweak it in a way that was as narrow as possible to ensure that there was no lacunae in protection. And so I wonder why 5 is so important. I also wonder why we can't restrict the Secretaries of State who could operate in place of the Prime Minister in this very particular circumstance to those Secretaries of State who also issue warrants, and why that can't be on the face of the bill. I hope that that the Minister in his response might have some sort of contribution to make about why the government seemed to be sticking on this particular issue, given that everybody understands how important it is to have resilience, but that the resilience I think the ISC are seeking is slightly stricter, I think, than the government seem to wish to grant, and it would be helpful, I think, for committee stage if the Minister might be able to give us some view of why that is. Mr. Deputy Speaker, I think it's important that the discussions we have on particular bits of this bill, which we will have particularly in committee, I know, are seen in the context of a widespread acknowledgement that we need to ensure that the investigatory powers that are involved in the amendment bill that we're debating tonight are updated, continue to evolve to make them relevant and efficient and effective to use. But at the same time, that the principle that any expansion in investigatory powers must have particular safeguards and oversight in a democratic country so that we can all ensure our constituents that this is being done in the interest of preserving our democracy, of ensuring that we can protect the population from the growing and ever-evolving threats, be it of terrorism, state actors or crime, but also that their human rights and their rights to privacy are still appropriately protected with proper oversight, which of course the ISC is an important part of.
Sir Julian Lewis.
Thank you, Mr. Deputy Speaker, and it's a pleasure to follow the Honourable Lady for Wallasey, who, as she mentioned, is the newest member of the committee, but that hasn't prevented her, as we've seen this evening, already making a valuable contribution to our work. As chairman of the ISC, I should like to set out the committee's view of the bill as a whole, based on the engagement that we've had with the intelligence community and with the government more broadly on this legislation. And in doing so, I pay particular tribute to our member in the other place, the noble Lord West of Spithead, who has already very clearly set out our committee's position there and had success in at least one respect of obtaining an improvement to the bill. In looking at the bill as a whole, will also touch on one other specific matter afterwards, in addition to those which my colleagues have been tackling individually. Now, as honourable and right honourable members on both sides of the House will be aware, the original Investigatory Powers Act was introduced as a result of the Intelligence and Security Committee's 2015 report on privacy and security. That recommended that a new act should be created clearly to set out the intrusive powers which are available to intelligence agencies, the purposes for which they may be used, and the authorizations and, crucially, the oversight which should be required. There have, however, been a number of developments since that Act was introduced, and as the Home Secretary said in opening the debate, we now face a different threat picture with greater danger from state actors, a significant rise in internet-enabled crime, and an ever-accelerating pace of technological change. The ISC has therefore made time to consider and scrutinise the case for change as put forward by the intelligence agencies and the government, and to take classified evidence on the bill itself. I can tell the House that broadly the committee welcomes this bill as a means of addressing these developments, which have the potential to undermine the ability of the intelligence agencies to detect threats and to protect our country. However, as we have heard already, there are several areas in which the committee considers that the bill goes too far. In particular, it doesn't yet provide the safeguards and oversight which are so essential when it comes to secretive actions which have the potential to intrude on a great many people. The bill is seeking an expansion in the investigatory powers available to various public bodies. The committee is in agreement with that, at least in the case of the intelligence services, that this is justified. But I would note at this point that we are still sceptical, and this was very eloquently presented in more detail by my right honourable friend for South Holland and the Deepings, who had his own experience in taking the original legislation through when he himself was Security Minister. So we are still sceptical of the broad way in which some powers have been restored to an unknown number of as yet unidentified public bodies through Clause 14 of the Bill. Any increase in investigatory powers ought to be, indeed must be, accompanied by a concomitant increase in oversight. That is a very basic principle which Parliament has always expected to be followed. By oversight, I don't just mean parliamentary oversight as exercised by my committee, but also robust ministerial, judicial, and regulatory oversight too. The members of the Intelligence and Security Committee will be seeking, during the passage of this bill, to ensure that the necessary safeguards are included. We will also be seeking to ensure that sufficient detail on those safeguards is included on the face of the bill itself. The bill deals with a number of technical areas where it's right that the guidance necessary is provided in codes of practice. However, those matters which deal with procedural safeguards or external oversight must be on the face of the bill to ensure that they are adhered to and cannot be changed or watered down without Parliament being consulted. In recent years, the government has, I'm sorry to say, been reluctant to ensure that democratic oversight keeps pace with intelligence powers, particularly where it's related to the remit and to the resources of the ISC, which have been increasingly undermined in a way that I believe Parliament never intended. It's therefore imperative that Parliament ensures that the safeguards and scrutiny provided by the ISC and other external oversight bodies, such as the Investigatory Powers Commissioner, is clearly set out and cannot be discarded on a political whim. That means putting it in the legislation itself. Fine words in a code of practice are, I'm afraid, not worth the paper they're written on. The statute itself must include everything that's needed to provide Parliament and the public with the necessary assurance that investigatory powers are tightly drawn and robustly scrutinised. The committee therefore expects the government to take this opportunity to bolster the effective oversight that it keeps saying that it values. Actions speak louder than words, as is often said. So I look forward to hearing the Minister's assurances in his response to our interventions, and I hope that he'll be able to find a solution both to the individual aspects of the bill, which have been raised and are continuing to be raised, and to our overarching concern over the diminution of parliamentary powers in respect of national security. Now, I would like to highlight one particular issue which concerns my colleagues and myself on the ISC relating to the oversight requirements for the retention and examination of bulk data sets, bulk personal data sets. Clause 226DA of the bill requires that each intelligence service should provide an annual report to the Secretary of State detailing the individual bulk personal data sets which they retained and examined, either under a, quotes, category authorization or under a, quotes, individual authorization during the period in question. In the Upper House, Lord West, on behalf of the committee, proposed an amendment which was designed to ensure that there is independent parliamentary and judicial scrutiny, I emphasise that, judicial scrutiny as well, of this information rather than just political oversight. It would achieve this by providing that the annual report which the government's proposing to send to the Secretary of State should also be sent both to the ISC and to the Investigatory Powers Commissioner. You'd think that was a pretty reasonable request. This would rectify the current gap in parliamentary oversight of these authorisations and complement the Commissioner's existing powers of inspection to provide oversight at all levels. Unfortunately, the government did not accept this amendment. However, they did at least acknowledge that the gap existed and that some level of parliamentary oversight of the new regime was needed. The government therefore introduced its own amendment, which rather than providing the ISC with the same report that it's providing to the Secretary of State, places an additional duty on the Secretary of State to provide a separate report to the ISC. Notably, this report, even this secondary report as it were, would not be provided to IPCO. You can see this government clause that's been added at 226DB. Now, while we are reassured that the committee's strength of feeling, which was matched by the feeling of noble lords in the upper house, has been recognised by the government, what concerns the committee on this specific matter is why the government has chosen to craft a separate amendment requiring a separate report to be drawn up. There are three key differences between the committee's and the government's proposals, of which the House will wish to be aware. The first difference is that the government's proposal will actually create more work for the intelligence community. That is because instead of simply sending the existing annual report to the ISC, they will have to produce an additional report. This seems entirely at odds with the government's general approach to the bill. The minister in the upper house was keen to emphasise the need to minimise the burden on the agencies when it came to other elements in the bill, so it's most peculiar that they're deliberately choosing to increase the burden unnecessarily. The second difference is that the government proposal excludes the Investigatory Powers Commissioner completely, and it's not clear why. There, the Commissioner's oversight should be regarded essential because that is what it is. However, the third and most important difference is that the government amendment is less specific on the information to be provided to the Intelligence and Security Committee, and it does not include individual authorisations within its scope, only category authorisations. It therefore doesn't provide the same level of assurance to Parliament and the public that the ISC will be fully cited on the operation of this new regime. It is this final point that is causing us most concern. I therefore seek assurance from the Minister that the government proposal will not limit the information received by the ISC to category authorisations, and that all the information contained in the report to the Minister will be contained in the report to the ISC, unless it is material which falls strictly within the definition of current operations at the time at which the report is provided, because we do accept that that is the one thing that we don't generally see. And that definition should be strictly as set out in the Justice and Security Act 2013. So any excisions beyond that would undermine what we presume is the intent here to provide assurance to Parliament and the public that the regime has robust democratic oversight. Finally, Mr. Deputy Speaker, I simply reiterate the key point. This bill seeks an expansion in investigatory powers available to the intelligence services. Whilst this expansion may be justified, any increase in investigatory powers must be accompanied by a concomitant increase in oversight, and they haven't yet fulfilled that requirement.
Kevan Jones.
Thank you, Mr. Deputy Speaker. I'd just like to start by just saying thank you to the members of our security services. I think now the longest serving member on the ISC, and I've got to say it's a privilege to work with them as we do on the ISC and scrutinise the work they do. They don't get, for quite right reasons, a great deal of publicity, and if they do sometimes, it's sometimes not factual in any imagination, but they do an invaluable job. And that threat which they face, and that we all face in protecting our democracy, is changing, and it's quite right. The 2015 Act does need revising. But as my honourable friend for Wallasey said, the important point is that any new powers we give the security services to act on our behalf should also come with the equally balanced level of scrutiny and oversight. Now, I see scrutiny of our security services really as like a three-legged stool. We have the Investigatory Powers Commission, we have the Investigatory Tribunal, and then we have the ISC. Well, I would actually say, Mr. Speaker, it's more like a 2.5-leg stool, because the Home Secretary did what most government ministers do by saying how wonderful the ISC is, and how they value our work, and that they want us fully involved with, for example, the passage of this piece of legislation. Can I just say, over the last, since 2017, I think I first went on the committee, there has been a marked increase, and I think we've got it again today with this bill, of paying lip service to the ISC. It's a point that my honourable friend from the front bench made, is that we've not met the Prime Minister for 10 years. Any of them. We had one, I think, which offered to come in her dying days of administration. And if you look at the way in which the government are approaching this bill, we've taken evidence from the security services on this bill, and I've got to say, they aren't the problem. It's the government's that's the problem all the time. We had that with the National Security and Investment Act, where, frankly, it is an uphill struggle to get things changed in this bill, which you would think would not only improve the bill, but make sense. One's just been highlighted by the chairman of the ISC, the member for New Forest East. And it's a little bit like going around in circles with them on occasions. And I give an example that we've actually made one little advance in the other place in terms of the acceptance of the changes in terms of the triple lock. But then the sensible thing, just to say that what we were asking was that then it should be on the face of the bill that the Prime Minister should actually see those warrants, is somehow being resisted as though this would, stop the world. Well, I'm sorry, I don't think it would. And it's the idea, I think, from the government that somehow they've got it seen to be resisting any types of thing. And, I like the Minister, but I've got to say, the passage of the National Security Investment Act was a pretty dark day for the government in terms of relationship with the ISC, because we had to fight tooth and nail to try and get anything changed in that bill. And if you, I think you were actually, you picked up the tail end of it, I think. But if you actually look at what we're proposing, we have looked at this in detail. We have taken evidence from the heads of the security services. And we want to be supportive of change, but we also want that important role, which is one of scrutiny and ensuring that the public are protected from the occasions when things might go wrong. The one area I would like to concentrate, and the other thing that struck me today was the Home Secretary can read a good speech. I'm not sure he had a great grasp of the actual bill, though, in terms of some of the detail. And all I would say to the Minister is, if we're going to make progress at report stage, at committee stage, is please take on board some of the things we're saying. These are not radical things that are going to, upturn this bill. They are things which will actually improve the bill. But I suspect in government there's this I think hatred in certain parts, I would say, of the ISC, that somehow we've got to be resisted at all cost. And I think that will lead to a poorer bill, because what we're putting forward, I think, in the amendments we will be putting forward, and Lord West did a great job in the other place, would actually improve this bill. Can I just touch on the issue of Part 7, which is the bulk personal data regime introduced under this bill. And there is a worrying gap, and it's the oversight of what is deemed as low or no privacy data sets added to categories of authorisations. Now, at the moment, it doesn't work because things like the electoral register have to get special permission. Well, that's silly, frankly, but we actually do need to ensure that these are, do have a scrutiny of them. So, Honourable Beware under Part 7A of the bill provides for a light touch regime for the retention and examination of bulk personal data sets by the Internal, where the subject of the data is deemed low or no reasonable expectation of privacy. And the Honourable Member who spoke for the Scottish National Party raised the point that increasingly people give their personal data with little thought about how it's going to be used, not just, say, for the intelligence services, but for commercial purposes as well. And I do think this does need looking at. So approval of such a data set will either be sought under a category authorisation, which encompasses a number of individual data sets that have a similar content and may be used for similar purpose, or an individual authorisation where the authorisation covers a single data set that does not fall neatly into the category of authorisation or is subject to a complicating factor. In the case of the category authorisations, the Judicial Commissioner will approve the overall description of the category authorisation before it can be used, and the Judicial Commissioner will approve the renewal of that authorisation after 12 months, and the relevant Secretary of State will receive retrospective annual reports on the use of that category in individual authorisations. However, as the bill is currently drafted, this oversight is all retrospective. So what is the problem with what is missing is real-time or even near-time oversight of changes. Under the present regime, once the category authorisation has been approved, the intelligence services have an ability to add individual data sets to that authorisation through internal processes alone. They examine the data set without subject to any political or judicial oversight, and they would not be able, they would not be used, those data sets, for potentially a year without anybody being the wiser. Therefore, it's good. We don't question why the security services need these powers, but there's potential here for mission creep without any oversight of what is being authorised. So, as we say, we're not saying that this is something. These powers are not required. They are required. But what we've been asked to do really is have the good faith of the intelligence services that these will be used in a certain way. Well, I don't think that is strong enough. No legislation should be dependent just surely on the basis of goodwill, and we've got to also guard against, because we do have occasions when mistakes happen, or people do use this for purposes which will not be in the individual public interest. So it's important we fill this 12-month gap, and the ISC thinks the easiest, simplest way to achieve this would be for the Investigatory Powers Commissioner to be notified when a individual personal data set is added to by the agency to an existing authorisation. I understand that Lord Anderson of Ipswich, in his review of 2023, recommended a similar type of proposal. Now, the argument from the government is, and it's similar to what is being used throughout this bill, which the Chairman just remarked on, is that this will be onerous and adding to the work of the intelligence services. Well, it wouldn't, because what it would be doing, it would be simply a one-line email to the Investigatory Commission containing the name, description of the bulk specific data set, as soon as reasonably practical, to be approved internally, and then sent to the Investigative Powers Commissioner. So it's not actually asking for approval, it's just making sure that the Investigative Powers Commissioner is aware of what is actually being added, and also that those individuals taking that decision realise they've got to inform the Investigatory Powers Commissioner. So obviously it would allow the Investigative Powers Commissioner to look at trends in terms of what's happening, and also that clearly after the 12 months could look back, but also could intervene if you thought something was was not in touch. So there's an argument that you're saying this in this bill, and the government use it quite often as a light touch approach. I think, Mr. Deputy Speaker, this is a light touch approach. I don't know what's onerous about the Security Service sending an email to the Investigative Powers Commissioner, but I think it would ensure that there's that oversight which is needed. Real-time oversight, I think, is what we're suggesting, and I don't think it would add to, as I say, the administration of the actual of the security services. But what it would do is lead to another layer in which decisions that have been taken at least have got some visibility by the Investigatory Powers Commissioner. So I think it's a very simple thing to do, and I don't understand why the government are resisting it, but I suggest they're resisting it possibly for many of the other reasons why they're resisting some of the most sensible things we've put forward, just because they want to do that. And I just don't know, Mr. Speaker, how we go forward with the relationship between this present government and the ISC, because it is getting to a point, as the chairman said, not just in terms of trying to drag information out and screaming and kicking, even though we have a legal duty and to actually get information. It takes a long time. And the critical point now is the starvation of resources from the committee, which are creating real problems for the way in which the committee can operate. I hope that things change and that when we put amendments down, that we won't get the usual response that amendments to this type of legislation should only be done in the Lords. Are we here to cause trouble for the security service? No, we're not. We want to ensure that we do our job, which is set out in statute to do the supervision of the security services and improve the powers, but also ensure that the public have those recognised safeguards which we should expect in a democracy such as ours.
Charles Walker.
Well, thank you, Mr. Deputy Speaker. Unlike most people here, I'm not an expert on security. It is the case in this House that often we have to be generalists. We're here to participate in debates, to understand legislation and raise concerns where we see them. But like all members in this place who've spoken before me, I would like to put on the record my deep gratitude to our security services. I hold them in the highest respect. We all hold them in the highest respect. And within that, there is a slight danger. And that slight danger is this, that we respect them so much, we admire their work so much, we are almost always going to grant them what they want. And that is a danger, Mr. Deputy Speaker, because actually our duty is to scrutinise what people want, and as the Honourable Gentleman for North Durham just said, not create trouble, but to raise questions of concern. And I know these questions of concern will be well received by the Minister on the front bench, who thinks deeply about these matters and is also a good friend of mine. So, can I just briefly, and I will be brief because we're coming to the end of the evening, look at clause 15 of the bill in regard to internet connection records. Now, Mr. Deputy Speaker, the general rule of investigation is that suspicion precedes surveillance. So if there is good reason to believe that someone is up to mischief, then you can start to look at them more closely. You can conduct surveillance to see if your concerns are factually based. The problem, I think, with the recommendation in Clause 15 of this bill is that actually it allows for target discovery as opposed for target development. And if I've got this wrong, I'm happy to take an intervention. But what target discovery means to this layman of security matters is possibly going on fishing expeditions, just looking out there to see what's going on, processing enough data on enough people, and as my right honourable friend for Kenilworth and Southam said, people who are perfectly innocent going about their business but caught up in this data processing machine just to make sure they're not up to anything nefarious, dangerous or unpleasant. And that does cause me some concern, because I do want bad people caught. I benefit from the capture of bad people. My constituents benefit from the capture of bad people. But surveillance always does need to be proportionate and risk-based, as the Right Honourable lady from Wallasey mentioned in her speech. Freedom is important. I mean, one of the most ridiculous constructs in the English language is nothing to hide, nothing to fear. Because if people saying that genuinely believed it, they wouldn't have any curtains, would they, for their homes? The truth is, we like to think that we have private space in which to operate, to go around our legitimate business without the state taking a view that we're up to mischief or might be up to mischief. And I know that this was touched on in previous speeches. The chairman of the committee, who is also a good friend, I think touched on this. Sometimes it's difficult to keep up with experts, but I think he made it very clear that the committee had concerns around these new powers. So I said I would speak briefly, but I would just close on this. There are people in this country who like to protest and, quite frankly, often get in the way of other people. But what they're doing isn't illegal. And I would hate to think that people within those organisations might end up having their internet records checked out, just to make sure they were being good citizens. I remember during the debates around COVID-19, there were perfectly respectable, hugely respected scientists, and they were respected members of this chamber raising concerns about government policy in regard to lockdowns. And it seems, I'm not saying the security services were keeping tabs on their interventions, but through subject access requests, people were in government keeping tabs on these people, as if what they were doing was against the interests of the state. And this is why I raised my concerns on this clause. I hope the government will bring forward amendments, but if it doesn't, I hope the government won't be too offended if perhaps I bring forward some amendments at report stage. Thank you, Mr. Deputy Speaker.
Final speaker before the wind-ups, Jim Shannon.
Thank you, Mr. Deputy Speaker. Can I, first of all, thank all right honourable members for their contributions to what is a very complex issue. It is clear from the level of scrutiny and debate that we have seen thus far, and the reason is very clear. The bill does need to find a balance. The Shadow Minister referred to that very word, balance, between allowing for necessary investigatory powers and that of a big brother on the nanny state. Can I thank, first of all, as others have, Mr. Deputy Speaker, our thanks to the security forces, to those involved in the intelligence sector for all that they do, for their very work, Mr. Deputy Speaker, and their commitment and their dedication to the job has made all of our lives safer. And really, I think there may be many in this House, I can know a few anyway, who could say they owe their lives. Indeed, I would be one of them, Mr. Deputy Speaker, so I thank them very, very much for all that they have done. I'm also very keen to see the issue of international terrorism. I was talking to my honourable friend and colleague, very honourable member for Durham, and I was just saying to him about how international terrorism works. Real IRA have contacts in the Middle East, they have contacts in Eastern Europe, they have contacts where they can, all evil organisations come together because their ultimate intention is to create havoc and murder people, innocent people. So when it comes to this bill, and why is it important? Because it can address terrorism in Northern Ireland and its contacts with international terrorism. And I hope and pray that the work that they do will be successful. And as someone who's lived through years of terrorism, I've been very well used to curtail freedoms with checkpoints, with stop and search. And I've understood the necessity for all of this, and I've been thankful for those protections. And let me be very clear, I have no issue whatsoever with this bill in principle, but I have some questions which I wish to ask the Minister. However, I've been contacted by various constituents who have raised issues with me regarding their concerns. I just want to put these on record, ever mindful that I'm very mindful to support government in this issue as it comes forward. And just take a few moments where I seek some clarification. Firstly, in terms of the introduction of a notification requirement requiring operators to inform the Secretary of State if they have proposed to make changes to their products or services. Concern has been outlined to me, and I'm sure other members have received this as follows. And I quote, firstly, with regard to why this objective may appear reasonable, it would allow the Secretary of State to prevent secure services from launching in the UK, even were they deployed elsewhere. The provision would allow the Secretary of State and the Home Office to place itself in a position of power over the provider as soon as it hears about updates that might make data less accessible than it is currently. The situation would take place without reference to an independent authority to assess the rationale or proportionality. Such a move might not be proportionate, for instance, if the security technology had already been introduced safely and with demonstrable benefits to users in other parts of the world. Open Rights Group is concerned, and I quote, these powers could deny people access to technological developments upon which people's free expression and right to privacy rely. And for example, major tech providers such as Apple have stated that they would pull certain services from the UK rather than compromise their security if this power was used to prevent them from rolling out security updates. So again, I would ask the Minister very gently to be clear why the presumption shouldn't be made in this manner I have outlined, and what discussions have taken place to ensure that providers such as Apple, etc., can securely work in the UK. I think the Honourable lady, forgive me for not remembering her constituency, she was the Secretary of State. I know Hansard will correct it. And she referred to the dark web and all the things that can happen in that. So really important that within this legislation we have before us, that the dark web is taken care of. In addition, highlighted to me were issues of end-to-end encryption and the inability of service providers to see the contents of service users in their apps and systems. Now, I'm not, Mr. Deputy Speaker, a technical whiz kid. I'm the very opposite. I'm that old generation who can just about do the text messages on the phone, do the Zoom meetings to turn it on, and then if something goes wrong, I'm lost. That's where I am. So when it comes to technology, I'm not au fait with it. But I do know this, that I understand the need of people with no question mark above them whatsoever to know that messages are private and that government is not storing information in them for no reason, which can be then accessed by others. So important that never happens. The data breaches of staff, my office staff included, in this house just in the last fortnight, where there's a breach of my accounts were hacked in this house. We let the security people know that. It's not unusual for it to happen, I understand, Mr. Deputy Speaker, but when it happens and access is made to your contents, then it's very important that the breach is taken care of. Also, the breach of police officers in Northern Ireland are testament to the fact that breaches occur, and therefore only what is essential should ever be gathered and stored. And I think the honourable member, one of the other members who was speaking earlier, referred to the need to have robust monitoring and regulation of that. If that had been in place, the data breaches would never have happened with the PSNI, which was over 3,500. I think it was people who were disadvantaged. Whilst I cannot browse and shop online, indeed have no interest in shopping online, watch TV programmes online or do any of these other things, I do believe that there is a need for privacy, and my concern is that this bill is encroaching too far on those who have no reason for their government to hold the data. And I would ask the Minister again to make clear why any online search history should be stored. These are gentle questions, they're not meant to be intrusive, aggressive, but I think it's important I put these matters on record on behalf of the constituents who have contacted me. Briefly, I would highlight the concerns that the proposed measures in the Investigatory Powers Amendment Bill are poised to. And this is the words provided to me by a constituent, again not my words, and I quote him: "This can profoundly impact upon political dissidents and opposition figures residing in the UK. Refugees, political exiles, human rights advocates who have sought refuge within the United Kingdom of Great Britain and Northern Ireland deserve the assurance of digital safety and security." So I seek that assurance for those who have fled offensive and oppressive regimes and sought refuge in this great United Kingdom of Great Britain and Northern Ireland. I finish with this comment to keep within the time that I give you, Mr. Deputy Speaker. I will finish it. I'd further appreciate an insight into how we can ensure there's freedom to express opposition and yet not harmful rhetoric. And it is clear that this balance is very difficult to reach. And I seek the necessary clarification at this stage that we have struck the balance. And I look very much forward to hearing from the Minister, because I do believe that his response will encapsulate the questions that we've asked and give us the answers that we desire. Thank you so much.
Thank you very much. Wind-ups, Dan Jarvis.
Thank you, Mr. Deputy Speaker. The Investigatory Powers Amendment Bill is a technical but important piece of legislation, which, as my right honourable friend, the Shadow Home Secretary, said in her opening remarks, is one that we support. We support the bill, which updates aspects of the Investigatory Powers Act 2016, because it's imperative that legal frameworks are updated to ensure our security and law enforcement services keep up with changes to communications technology in an increasingly challenging and complex landscape of threats to our safety and our national security. Let me, at the outset, pay tribute to the exceptional men and women who serve in our law enforcement and security services, sometimes often in the shadows and without recognition, to keep our country safe. We owe a deep debt of gratitude to all of them. Can I also thank officials at the Home Office who provided very helpful briefings to the Shadow Home Office team on the bill. And I hope the Minister will join me also in paying tribute to our noble colleagues in the other place, especially Lord Anderson, Lord Sharp, Lord Coker, Lord Ponsonby and Lord West, amongst many others, who've already done a lot of the intellectual heavy lifting, digging into the technical details of the bill to improve it ahead of its second reading here today. Whilst these contributions are most welcome, the bill still needs to be scrutinised in more depth to probe any remaining ambiguity and ensure that safeguards are strengthened. And I'll say a little bit more about this later. Now, Mr. Deputy Speaker, as the Shadow Home Secretary said, the opposition will work in the national interest with the government on national security because, as legislators, we all have a duty to ensure that the law is one step ahead of those who seek to harm us. And as lawmakers, we also have a duty to ensure that when there are quite technical bills before us on matters relating to national security, we scrutinise them carefully and get into the detail of them. Now, members on both sides of the House have fulfilled this important duty with a number of thoughtful and considered contributions in this debate, including the Right Honourable Member for Kenilworth and Southam, spoke, as he always does, with great authority and made important points both about oversight and the important point about the interests of economic well-being. And I am certain that we will return to those in committee. The Right Honourable Member for South Holland and the Deepings, a former security minister, I think helpfully reflected on his experiences of taking the original legislation through the House back in 2016 and made some important points about the role of public bodies. The Honourable Member for Wallasey, the newest member of the ISC, made, I think, a very important point about the context in which we are having this debate, with authoritarian regimes around the world constantly seeking to test the will of democracies. And she also made an important point about the importance of the balance between safeguarding our security and of oversight and transparency. The Right Honourable Member for New Forest East, the Chair of the ISC, spoke with his very long-standing experience about these matters and expressed very clearly the view of the committee. He made a number of important points, including about the safeguards that he seeks being included on the face of the bill, and I am sure that we will return to that. He also made the important point about any increase in powers coming with an increase in oversight. It was a point reiterated by my right honourable friend, the member for North Durham, who I think is the longest serving member of the ISC. He spoke about the 3, or is it the 2.5-legged stool, and I think he made a number of really important points and did provide a constructive challenge to government. I hope that working with him and the committee members and the Minister, we can all work together in committee to make some improvements to the bill. The Honourable Member for Broxbourne made what I thought was a typically carefully considered debate. And for someone who claimed not to be an expert, he made a number of very important points, I thought, not least about surveillance needing to be proportionate. And the Honourable Member for Strangford reflected, as he often does, with great experience on his own experiences of dealing with the issue of terrorism in Northern Ireland, and rightly paid tribute to all of those who serve to keep our country safe. Now, Mr Deputy Speaker, I will now turn to aspects of the bill that I believe could well be improved. Now, the measures outlined in the bill continue to provide our law enforcement and security services with some of the most powerful measures our state has at its disposal to keep us safe, intercepting private communications and retaining their information where necessary. With these strong powers, there must also be strong, robust safeguards to guarantee their appropriate and proportionate use. So, when the Minister responds, I'd be very grateful if he could provide further assurances that the notices regime will be kept under constant review. These assurances are important, as the power to access telecommunications data through bulk personal data sets unlocks an individual's digital footprints of their online activity. Now, for those of a certain age, I don't have anybody in particular in mind, investigatory powers can conjure images of wiretapping telephone lines, and for those of a very certain age, even steaming open letters. But the modern reality is that huge amounts of data produced every second could be sifted through and used by law enforcement and crime agencies when there's a lawful basis to do so. Therefore, this bill must clearly establish a precedent of proportionality. For example, further defining what low or no reasonable expectation of privacy in Clause 2 means relating to certain bulk personal data sets. So I'd be grateful if the Minister could outline how the Government intends to do this. Now, Mr Deputy Speaker, the UK's use of investigatory powers should be clearly understood by our international partners. Vast amounts of telecommunications data, such as WhatsApps, are now stored in servers across many jurisdictions by multinational companies with sometimes complex corporate structures. For example, I understand Meta has stringent measures to protect these servers from cyber attacks, preventing WhatsApp messages from being interfered with or accidentally deleted. Mr Deputy Speaker, if only the same stringent measures existed with some members of the party opposite, and with the SNP for that matter. Moving swiftly on. A warrant to intercept messages between two UK nationals in the UK could be stored in a server in another jurisdiction. In relation to the bill before us, this leaves potential conflicts of law to arise in Clause 17, which would strengthen extraterritorial enforcement of retention notices. Therefore, I'd be very grateful if the Minister could say something about the feedback the Home Office has had from international partners about potential conflicts of law that could arise from Clause 17 of the bill, and what actions have been taken to avoid any potential conflicts. Also, can the Minister say what recent feedback the Home Office has received from companies providing messaging services in the UK who use servers storing communications data in other countries? Ensuring the utmost clarity in the measures outlined in this bill must also include when they are applied in the most exceptional circumstances, such as when the Prime Minister cannot make a decision to sign off an interception warrant. Now, the Shadow Home Secretary mentioned rightly the importance of Prime Ministers treating these matters with the utmost of seriousness. And this was discussed and debated in detail when the bill was progressing through the other place, with the term unable being used if a Prime Minister can't make a decision compared to other terms such as unavailable. Now, the Minister, I expect, will be relieved that I don't plan to spend too much time on this, but that isn't to underplay its importance. The debate between noble colleagues on whether unable or unavailable were the most appropriate term may have been, in part, generated by the activities of two former senior figures in government, neither no longer serving members of Parliament. For the benefit of the House, I will just say that one of them might have been a Foreign Secretary who became Prime Minister, and the other might have been a Prime Minister who became Foreign Secretary. Now, Mr Deputy Speaker, on the crucial role a Prime Minister plays in making decisions on national security, can I remind the Minister, and other honourable members have also sought to remind him during the course of this debate, that since 2014, successive Prime Ministers have failed to meet with the Intelligence and Security Committee. This, as we all know, is a senior committee of Parliament that provides absolutely vital oversight on these crucial matters. We heard from the Chair, and I think he made some very important points. So can I, again, ask the Minister to say why he thinks no Prime Ministers have made themselves available to the committee for a decade now. Furthermore, recent updates to the IPA 2016 after the ruling of the European Court of Human Rights on the case of Big Brother Watch and others versus the United Kingdom provides further safeguards to protect sensitive information relating to freedom of expression, such as journalistic material, from the usual interception and retention regimes. Other elements of freedom of expression should also have similar safeguards. So can I ask the Minister to say whether he thinks there should be similar exemptions in the bill for communications relating to the vital work of trade unions? It was a point also made by the Honourable and learned member for Edinburgh South West. Mr Deputy Speaker, to conclude, this is an important bill that demands strong and careful scrutiny. Both our personal liberties and our national security depend on it. It's in the national interest to get this legislation right, to make sure it is both appropriate and proportionate in its scope. It must also be effective in maintaining the current powers our law enforcement and security services already have in disrupting and defeating criminals and malign actors that seek to harm us and undermine our way of life. On these benches, we will work with the government as much as we possibly can in the national interest to get it right. And I look forward to working with the Minister and with other colleagues in this important endeavour as the bill progresses through the House. Thank you.
Minister. Thank you, Mr Deputy Speaker. May I just start by thanking members and honourable members from all across the House for their contributions, not just today, but actually throughout many different stages that this bill has been through. I must say, I not only pay huge tribute to the members of the other House who have contributed enormously, in particular, if I may, to Lord Anderson, who has been an exceptional asset to the passage of this bill in the condition in which it is, but also to Lord West, who, as member of the ISC in the other place, not only shepherded some extremely important amendments into this bill, but was kind enough to say that it was the first time in 14 years he'd ever had an amendment accepted by the government. And I'm delighted to say that it was in this bill, and it was because we are so committed to working with all parts of this House and so committed to working with the Intelligence and Security Committee that we've got so much of this through the House, in the House of Lords. That said, there are many comments that will no doubt be raised in this House, and I can assure honourable members, especially the Right Honourable Member for North Durham, that I will approach all suggestions in the way that I have done to date, and where we may not agree, it may not be that he is right or that I am right, but it will be for good reason, and I will set out my reasons as appropriate in the appropriate way. May I just say, though, that this bill is absolutely about one fundamental thing, which is about the security of the British people. And the truth is that while we have quite rightly heard from the Right Honourable Member from Broxbourne about the nature of freedom, the truth is freedom without security is impossible. It's a chimera that simply cannot exist. And this bill is about making sure that the British people have the security in order to enable that freedom. Now, that is an absolutely vital responsibility, not just of this government, but also of this House and the other place. And I'm grateful for the work that my honourable friend from Barnsley Central, and indeed his right honourable friend, the Shadow Home Secretary, has put into making sure that this bill has been approached in the cooperative, bipartisan and indeed open fashion that I think not only is merited by the work that our fantastic intelligence services do, but actually is merited by the security, in order to provide security for our whole country. Now, as the British public would expect, we keep our approach to national security under constant review. And where we identify the need for change or improvement, we will not hesitate to act. And that's why we brought forward this bill, which acts upon the findings of the Home Secretary's report and the Lord Anderson's independent review into the Investigatory Powers Act. The nature of the threats we face has evolved rapidly since the 2016 Act, and Honourable and Right Honourable members will not need me to rehearse the arguments, but it is pretty clear that since the 2016 Act, the nature of Russia's threat to the whole of Europe, not just to Ukraine, the nature of the violence that Iran is trying to bring even into our own shores, not just into the Middle East, and of course the way in which technology is changing the way that hostile states can not only steal our technology, but can introduce intelligence gathering platforms into our country through the guise of car sales, is quite extraordinary. We have seen a change in the way that technology works and the change in the nature of the threats, which means that we have to keep up to date with that. And that is why this work is so important. Because it is essential that the UK's investigatory powers framework remains fit for purpose to help our intelligence agencies detect and stop some of the most serious threats posed to the United Kingdom and its citizens, including from terrorism, from the state threats, and from child sexual abuse and exploitation. Of course, given that these are exceptional powers, Honourable and Right Honourable members have made quite rightly the point that they do require appropriate, robust, and indeed in this case, very clearly world-leading safeguards, and that is what we have sought to set out. Now, this bill, or rather the changes in the bill, are relatively narrow in scope, but without making them now, the ability of our agencies to tackle evolving threats will be increasingly constrained in the face of global instability, technological advancements, and state hostility. So now is the time to act. Now, if I may, I will go through some of the points that have been raised. The Honourable Member for Glasgow South raised, I think, rather an interesting point on the changes to lawful authority with regards to data published data in Clause 12. The purpose of subsection 3A is that material which has already been published should not require additional authority for its disclosure by a telecommunications operator to a relevant public authority. The definition of publish and reference to a section of the public would not include private messages unless they had been made public in some other way, in the same sense as your sitting room could not be considered a public place unless you opened it up to the public. That would be your choice and not the nature of the building. The Honourable Lady for Edinburgh South, who has made important contributions to this through her committee, South West, forgive me, also raised questions about the IPA 2016's transparent safeguards, incredibly robust safeguards, centred around the considerations of intrusion into privacy. This will remain the case in this bill, and this includes a requirement for investigatory powers to be used in a necessary and proportionate way, with the independent oversight by the Investigatory Powers Commissioner and redress through the Investigatory Powers Tribunal. The Honourable Member for South Holland and the Deeping who contributed in his usual robust fashion to this debate, and may I say also to the session that I was fortunate to have with the Intelligence and Security Committee, in which he assisted me in making some changes to this bill, which were enormously helpful, spoke about the different individuals who could be designated by the Prime Minister, the 5 names, and why we hadn't specifically said those with warranting powers. It is possible that some minister with warranting powers who had that experience was then moved to another department, or indeed that machinery of government changes changed the nature of the oversight. And so while we felt that it was right to limit to as few as possible, we also felt that it was right to have a relevant selection, and that's why we left the number at 5. This was after, I have to say, very good consultation with the ISC, and for which I'm extremely grateful to my right honourable friend, the member for New Forest East, for his contributions on that debate. If I may now turn to the right honourable member for North Durham, who will no doubt... I will, of course.
Just before my honourable friend, who's been immensely generous, both in giving way and for his earlier comments about my role, would he just deal with this issue of the other bodies with a regulatory function who can compel the release of communications data? He will remember that the point I made was the existing law obliges them to take further procedural steps before they do so. Why isn't that any longer deemed appropriate?
The right honourable member will know that there are several powers in this in the earlier bill, the one in fact that he took through the House, that were indeed overseen in various different ways. This bill doesn't seek to undermine any of that oversight. What it seeks to do is to clarify in certain areas where that oversight is necessary. And where he where he highlighted the individual agencies or bodies, I will be very happy to write to him to make sure that he's aware exactly where it is being covered.
Thank you.
If I may now turn to the right honourable member for North Durham. The honourable member spoke about prior judicial authorisation for ICRs. The purpose of this bill was to try to streamline operations for the intelligence services in areas where that risk was, as we're calling it, low or no expectation of privacy. And the honourable member will have seen in the bill what that expectation means, areas where information has already been readily made public. And the reason why we're not going down quite the route that he suggests, though I accept his commentary, and I'd be very happy to enter into further conversations with him. The reason that we're not currently going down that route is for the simple reason that the existing law allows, as he knows, under the IPA 2016, the collection of bulk data with the prior authorisation. This is intended to speed it up. If we put in the measures which he's referring to, we'd effectively be remaining in the same place that we are. Now, that would make it harder. I'll finish my point and then I will give way. That would make it harder for this, for the volume of data that is now coming to be considered by the intelligence agency. That's why we've made it a subsequent approval rather than a prior approval, and that's why I take his point that it is a maximum of a year. I think it is unlikely that very much will go as the maximum of a year, but he's quite right to say that that is the maximum. That will be in the cases where this is low or no, after it has already been agreed by a judge to be in the correct category. So we are looking at, I think we're looking at slightly through the other end of the telescope, but I'll give way.
What he's got to realise, and if he reads the Investigatory Powers Act as it is now, the passage of that Act, the big concern from the public, and let's be honest, the public aren't looking at the detail of this, is that somehow the security services are getting access to huge bulk data and just having a free will. All that I'm suggesting, which and the committee is suggesting, is that there's an email is sent when there is changes to the Investigative Powers Commissioner. That is a simple thing. It's not onerous, but what I think it does, it reinforces the point that at least there's some potential oversight of this process.
So I think I'm maybe conflating different aspects of this bill, but I do believe that this already has oversight through its... It does already have this oversight. And to answer, in fact, the honourable member for Broxbourne's point, which touches on the similar area, where people have the right and the expectation of privacy and freedom. This does not remove that right. What it does is it allows the intelligence agencies to use bulk data to target an individual at a particular point, and the excess, as it were, collected information is not able to be used for targeting of an individual without the warrantary process that would be expected for any initial search. So this is not, in that sense, this is not undermining anybody's privacy. What it's doing is it is allowing the very fact that now information is largely in bulk format. It is simply the reality that, as my honourable friend was talking about steaming open envelopes a little while ago, it is simply impossible to steam open a single envelope today. One simply has to steam open thousands for the very fact that that is how data comes. And therefore, without having an amendment like that set out in this bill, one would simply be interrupting the work of the intelligence services to the degree that it holds them back and makes that harder. I'm very happy to take this up with him a little bit later if he wishes. May I say also thank you to the honourable member for Halifax, who was here earlier on and made, I thought, an interesting point about the various different ways in which the MOU should be looked at through the National Security Act. And friends of mine will know my thoughts on that and will know that I gave a chance to the Conservative Party to allow me to change that 10-year absence, but the Conservative Party chose to choose somebody else to make that decision, and so I have sadly lost the ability to have that influence. And if I may, I'll turn to my right honourable friend for Kenilworth and Southam, who made a typically insightful speech and typically sensible comments on the ways in which we must consider the ways in which the authorisation must not be used to mount general surveillance. May I just touch on the fact that Condition D will only be used where an applicant can make a clear and compelling case based upon tangible, reliable intelligence leads and information analysis that the resultant data will identify parties involved in a relevant serious crime or national security related specified operation or investigation. The applicant must explain any anticipated collateral intrusion and how this will be managed to ensure the application is necessary and proportionate to the outcomes of the investigations. I hope if there are further points, I will very happily give way.
Well, I'm very grateful to him, and I accept what he says, but of course the case is being made to someone else within the intelligence agency in the context I was describing. There are, of course, two types of authorisation, D1 and D2. It's D2 we're worried about, and in D2, the application is made from inside the intelligence agency to inside the intelligence agency. That doesn't present the sort of external scrutiny that we suggest is necessary here.
The honourable gentleman is right, but of course he knows as well that the IPCO has oversight in retrospect on these areas, and where it comes under a category allocation through low and no, this has an automatic review period within a year. So although he's correct that it's within the service subject to a pre-agreed condition and with oversight following up, so as to enable that speedier response. I'll give way to the honourable member.
On a different but not unrelated point, so he'll recall that I referred to the annual report given to the Secretary of State detailing the individual bulk personal data sets which were retained and examined, and there was no extra work involved in letting the ISC and IPCO see that report, and the only possible justifiable exclusion would be something which at the time of the report was still current. Is there any reason at all why IPCO and the ISC should not be sent that report rather than some severely watered down version?
Well, the right honourable gentleman makes exactly, I'm afraid he answers his own question. The reason for the difference is because of the currency element. And I will give way again.
Well, in that case, if you would like to give us an assurance that the only difference between the two reports will be the exclusion of matters that are current at the time of the drawing up of the report, then we can reach agreement. But I suspect that there will be many other differences between the two reports as well.
I'll be very happy to talk to him about it and to make sure that we reach a satisfactory element on this, because I think it is important that we make sure that the reports that go to the House through the ISC, of course, because of the nature of the reports, but they are still going to the House, are relevant and allow the appropriate scrutiny. And I think we can all agree with that. If I may, I will now turn to forgive me as I move through some of the amendments that we've already covered. If I may, I will simply turn, I think. No, I have even covered the Honourable Member for Broxbourne's points, I think. Have I not? I have. There we go. In that case, I will turn instead simply to the Honourable Member for Strangford and to say that he made an extremely important point on the expectation of his constituents, as any other member of the United Kingdom, as any other citizen of the United Kingdom, should expect the right to privacy. I think, though, he also made, I thought, rather compellingly, the point about the need for security. And I think that this bill strikes that balance extremely carefully. He's right to say that people will be concerned, and he is not alone. I am also concerned that we may maintain that element of privacy and the right to privacy within our legislative framework. And that's why we checked very carefully that this was compliant and fully compliant with the ECHR and the right to a private life. And that's why also we looked at the various different exceptions. I'll just come, last of all, if I may, to the points that my honourable friend from Barnsley Central raised. The first is on the notices regime. Yes, he's right. We will keep it under review. We do maintain a regular conversation with companies that have an interest in this area. And he's right to say that there is an overseas element in this, but I would merely point out that I believe it is the role of this House to legislate for the security of the British people and in particular for the safety of our children and our families. It isn't something that we can outsource to tech firms on the West Coast, and therefore we have a responsibility sometimes, yes, to pass extraterritorial laws, and indeed we have done in the past, as he knows very well, and this adds a little to that. But it doesn't add in a way that I think it runs to the detriment. What it asks them to do is to maintain a position that they are currently in before making any changes and to talk to us during that period. That's not a requirement. That's not a requirement to break any of their policies or indeed to change a product or indeed to introduce a new product. It's merely to leave the status quo so that we can maintain the same ability to keep the British people safe until we've had a conversation as to how that status quo should change. If I may, on the last point, the Honourable Member raised the question of trades unions, and there are clearly many different areas where protected characteristics could come in to play, and I would certainly highlight areas like lawyers and doctors, psychiatrists, and many other different professions where the use of any such intrusive power should be done with exceptional caution. And he's absolutely right. I would just say that due to the nature of this place, due to the nature of parliaments around the United Kingdom, the position of parliamentarian is particular, and that's why it is set out specifically and separately in this bill. That doesn't mean that any attitude against any other individual should be used cavalierly. It's not a question of the role or the post that a person holds, but their rights as a British citizen. And those rights as a British citizen should be absolutely guarded from intrusion or aggression by the state without exceptionally good reason. And that's why I think that this amendment, which he's very kindly supporting, sets out that balance between the right to privacy of the British citizen, but also the right to security of our citizens as well. And with that, Mr. Deputy Speaker, I beg to move.
The question is that the bill be now read a second time. Mr. Madam, say aye. Aye. I think the ayes have it. The ayes have it. Programme motion to be moved formally.
I beg to move.
The question is as on the order papers. Mr. Madam, say aye. Aye. Contrary, no. I think the ayes have it. The ayes have it. Money resolution to be moved formally.
I beg to move.
Question is as on the order papers. May I say aye? Aye. No. I think the ayes have it. The ayes have it. We now come to motion number 4 on local government. Minister to move.
I beg to move.
Question is as on the order papers. May I say aye? Aye. No. I think the ayes have it. The ayes have it. Motion number 5 on social security, Minister to move.
I beg to move.
Question is as on the order papers. May I have been say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. Motion number 6 on social security, Minister to move.
I beg to move.
Question is as on the order papers. May I have been say aye?
Aye.
Contrary, no. I think the ayes have it. The ayes have it. Petition, Scott Benton.